Welcome to our comprehensive guide on business law and contracts. In today's fast-paced business world, understanding the legal framework that governs commercial activities is essential for success and risk management. Business law covers the rules, statutes, and regulations that dictate how businesses operate, interact, and resolve disputes. Whether you're an entrepreneur, manager, or just curious, this video will break down the core concepts of business law, focusing especially on contracts, which are the backbone of most business transactions. Let's start by exploring what business law actually means and why it's so important for every organization. Contract is a legally binding agreement between two or more parties. It sets out the rights and obligations of each party, ensuring that everyone knows what is expected. Contracts can be written, oral, or even implied by conduct, but written contracts are the most common and enforceable in business. They provide clarity, reduce misunderstandings, and offer legal remedies if something goes wrong. Understanding what makes a contract valid is crucial for anyone involved in business, as it helps prevent disputes and protects your interests. For a contract to be legally enforceable, certain elements must be present. These include offer, acceptance, consideration, mutual intent, and legal capacity. The offer is a clear proposal by one party, and acceptance is the agreement by the other. Consideration refers to something of value exchanged, while mutual intent means both parties genuinely agree to the terms. Legal capacity ensures that all parties are competent to contract. Missing any of these can render a contract void or unenforceable. Contracts come in various forms, each serving different purposes. Common types include express contracts, where terms are clearly stated, and implied contracts formed by actions rather than words. There are also unilateral contracts, where one party makes a promise, and bilateral contracts, where both parties exchange promises. Understanding the differences helps you choose the right contract for your business needs and ensures you're protected in different scenarios. The offer is the starting point of any contract. It must be clear, definite, and communicated to the other party. An offer outlines what one party is willing to do or provide and under what terms. If the offer is vague or incomplete, it may not be legally binding. It's important to ensure that your offers are specific and leave no room for misunderstanding, as this forms the foundation of a strong contract. Acceptance is when the other party agrees to the terms of the offer without changes. This agreement must be communicated clearly, either verbally, in writing, or through actions. If the acceptance alters the terms, it's considered a counteroffer, not acceptance. Proper acceptance is crucial because it signals that both parties are on the same page and ready to move forward with the agreement. Consideration is what each party gives up or promises in exchange for the other's promise. It can be money, services, goods, or even a promise to refrain from something. Without consideration, a contract is generally not enforceable. This element ensures that both parties are invested in the agreement and have something at stake, making the contract fair and balanced. Both parties must genuinely intend to create a legally binding agreement. This is called mutual intent. If one party is joking or not serious, there's no contract. Courts look for evidence that both sides understood and agreed to the terms. This requirement protects parties from being bound by accidental or casual promises. Not everyone can enter into a contract. Parties must have legal capacity, meaning they are of sound mind, not minors, and not under duress or influence. This ensures that agreements are made fairly and that vulnerable individuals are protected. If a party lacks capacity, the contract may be void or voidable depending on the circumstances. Contract must be for a legal purpose. Agreements to do something illegal, like commit a crime or fraud, are not enforceable. This requirement ensures that the law is upheld and that contracts are used for legitimate business activities. Always check that your contract's purpose is lawful before proceeding. While many contracts can be oral, written contracts are preferred in business because they provide clear evidence of the agreement. Some contracts, like those involving real estate or large sums of money, must be in writing to be enforceable. Written contracts help avoid misunderstandings and make it easier to resolve disputes if they arise. Contracts often include standard clauses to address common issues. These might cover payment terms, delivery schedules, confidentiality, dispute resolution, and termination rights. Understanding these clauses helps you negotiate better terms and avoid surprises later. Always read and understand every clause before signing any contract. Breach occurs when one party fails to fulfill their contractual obligations. This can be a failure to deliver goods, pay on time, or meet agreed standards. Breaches can be minor or major, and the remedies depend on the severity. Understanding what constitutes a breach helps you protect your rights and respond appropriately if things go wrong. If a contract is breached, the law provides remedies to the injured party. Common remedies include damages, monetary compensation, specific performance forcing the party to fulfill their promise, or cancellation and restitution. Knowing your options helps you decide the best course of action if a breach occurs. Negotiation is a key part of contract formation. Both parties should discuss and agree on all terms before signing. Effective negotiation ensures that the contract is fair, balanced, and meets everyone's needs. Don't rush this process. Take time to clarify expectations and address any concerns. Contracts go through several stages: negotiation, drafting, execution, performance, and termination. Each stage has its own challenges and best practices. Understanding the contract lifecycle helps you manage agreements more effectively and avoid common pitfalls. With technology, many contracts are now created and signed electronically. E-contracts are legally valid in most jurisdictions provided they meet the same requirements as traditional contracts. Electronic signatures are widely accepted, making business transactions faster and more convenient. Doing business globally often involves international contracts. These agreements must consider different laws, languages, and cultures. It's important to specify which countries' laws apply and how disputes will be resolved. International contracts require extra care to ensure clarity and enforceability. Not all contracts are enforceable. A void contract has no legal effect from the start, often due to illegality or lack of essential elements. A voidable contract is valid until one party chooses to void it, usually due to misrepresentation, fraud, or lack of capacity. Knowing the difference helps you identify and avoid problematic agreements. Some contracts can't be enforced by law even if they appear valid. This might happen if the contract is missing a required formality or violates public policy. Always check that your contract meets all legal requirements to avoid unenforceability. Contracts often allow parties to transfer rights or delegate duties to others. Assignment is transferring rights while delegation is passing on obligations. However, not all contracts permit this and some require written consent. Always review your contract's terms before assigning or delegating. Sometimes, contracts are made for the benefit of someone who isn't a direct party. These are called third-party beneficiaries. In certain cases, these beneficiaries can enforce the contract if the original parties intended to benefit them. Understanding this concept helps you structure agreements to include or exclude third-party rights. Disputes often arise over how contract terms are interpreted. Courts look at the plain meaning of words, the parties' intentions, and industry standards. Clear, precise language reduces the risk of misinterpretation. Always define key terms and avoid ambiguous language in your contracts. Contracts can end in several ways: by performance, mutual agreement, expiration, or breach. Understanding how and when a contract can be terminated helps you plan for the future and avoid unexpected liabilities. Always include clear termination clauses in your agreements. Force majeure clause excuses parties from performing their obligations due to unforeseen events like natural disasters or war. Including this clause protects you from liability when circumstances are beyond your control. Make sure to define what events qualify and the process for notifying the other party. Confidentiality agreements, or NDAs, protect sensitive business information from being disclosed. These contracts are common in partnerships, employment, and negotiations. They specify what information is confidential and the consequences for breaches. NDAs help maintain trust and protect your competitive advantage. Non-compete clauses prevent parties from engaging in competing businesses for a certain period or within a specific area. These clauses protect business interests but must be reasonable in scope and duration to be enforceable. Overly broad non-competes may be struck down by courts. Contracts often specify how disputes will be resolved, such as through arbitration, mediation, or litigation. Choosing the right method can save time and money. Always consider including a dispute resolution clause to clarify the process if disagreements arise. Lawyers play a crucial role in drafting, reviewing, and negotiating contracts. Their expertise helps identify risks, ensure compliance, and protect your interests. Involving a lawyer early can prevent costly mistakes and provide peace of mind throughout the contract process. Wrap up: understanding business law and contracts is essential for any successful enterprise. Always ensure your contracts are clear, complete, and legally sound. Pay attention to key elements, negotiate fairly, and seek legal advice when needed. By following best practices, you can build strong business relationships and minimize legal risks. Thanks for joining us on this journey through business law and contracts.